If you smoke, what you smoke? I got the pedals in the bathtub, girl, it's jumping, it's bubbling. I am playing no games, every word that I say is coming straight from the heart. So if you're trying to lay these arms, I'ma leave the door open. I'ma leave the door open. I'ma leave the door open, girl. I'ma leave the door open.
What up? What's going on, y'all? What's going on, Miss Jennifer? I am Queen Newton. What's good? Black Girl Beauty. Hey. I am Queen Newton. Hey. Miss Angela. Let's see where we at, y'all. Here we go. So, let me minimize myself so y'all can see it pretty good. Put myself over here. Okay, y'all can hear me? Okay, cool. All right, y'all. So it looks like there was... What's this right here? This is from the law offices of Thomas A. Farinella. Dear Judge Donnelly, we respectfully submit this letter as Robert S. Kelly's, or Mr. Kelly, emergency motion for temporary. They are trying to play off of the adrenaline of Mr. Bill Cosby getting released yesterday. So they feel like they're going to try to sneak a little way in to say, okay, right now it's kind of vulnerable. Don't forget about him. Right? So let's see what they're talking about. Is it buffering still? Good gosh. They probably reported my channel, which is all good. Maybe that's their plan. Anyway, here we go. So Mr. Kelly made 3 prior applications for bond and appeal. The district courts, y'all do me a favor, hit the like button, please. The only way to get across they buffering is to hit the like button. Yeah, they definitely trying to report the channel because I see the dislikes going up. So if y'all would please hit the like button, I would appreciate it. It says Mr. Kelly made 3 prior applications for bond and appealed the district court's denial for temporary release. Despite the second circuit's denial for Mr. Kelly's appeal decision, that we assume that adequate opportunity for consultation with counsel will be assured as a matter of trial administration by the judges who will preside over the 2 trials. This application is being filed to ensure that the second court's assumption hold true, as well as ensure that Mr. Kelly's constitutional right to counsel and constitutional right to a fair trial are adhered to in this case. Okay. So they're gonna talk about the background of this situation. Let's look at the background. It says here, so I gotta pull that up. It says here, since his arrival. Hold on, let me move this over. Can I move this? Yes. I'll move this over here. There we go. It says here that since his arrival on June 22nd, 2021, at the Metropolitan Detention Center at the MDC, Mr. Kelly has not been permitted to meet and confer with counsel in person and will not be able to do so until July 6, 2021, after he tests negative for COVID-19. It is undisputed that he is, It is undisputed that he is illiterate, which makes in-person meetings essential so that he can prepare for the August 9th, 2020 jury trial. Let me ask y'all a question real quick. Do you really think this man is that? I don't think he's as dumb as people say he is. Okay? When you look at how he writes music, the words he uses, his rhythms, his tones, his patterns, his melodies, his creativity, like, I don't think he's as dumb as people say he is. I think they're just using that as a crutch. I don't think R. Kelly's that dumb. Let's move on. It says here, since December 2020, while at the MCC, Mr. Kelly was granted the opportunity to attend FaceTime calls with his attorneys. Be very effective. The calls were constant situation. A request was made to the MDC for an accommodation of Mr. Kelly's disability to no avail. The court granted Mr. Kelly's request to view the discovery material in person. On August 8th, 2019, a stipulation and protective order was entered regarding the discovery materials, EF 132. In order for Mr. Kelly to be able to assist his counsel, the court allowed for one single copy to be given to Mr. Kelly along with a number of CDs. As of the date of this motion, after several requests by Mr. Kelly, the lead attorney at that time has not produced anything for Mr. Kelly's review. Although Mr. Kelly has literacy issues, he's indicated that he would rather struggle through it than not have it at all. Okay? Given the current circumstances that exist, Mr. Kelly, in the Special Housing Unity, SHU or the SHU, the lack of meaningful communication with Mr. Kelly while he is in prison, and Mr. Kelly's inability to assist in his defense, the only assurance that Mr. Kelly will be prepared for his trial in August is if he is granted immediate pre-trial release. The lack of ability to communicate with Mr. Kelly. Phone calls between inmates and their lawyers are an essential part of preparing an inmate for trial. Due to the fact that Mr. Kelly is in the SHU, access to him via phone has remained difficult and impractical when it comes to discussing certain legal strategies in order to properly prepare for trial. There is little preparation that can be done when Mr. Kelly calls counsel from a shower. There is little preparation that can be done when Mr. Kelly calls counsel from a shower and has to talk through a slit in the door. These barbaric conditions fundamentally prevent Mr. Kelly from being able to assist his counsel in his own defense. Meanwhile, every time Mr. Kelly speaks, everything he says is heard. Everything he says is heard throughout the SHU due to the acoustics and echo heard reverberating throughout the SHU prison walls. Again, not an appropriate environment to strategize with Mr. Kelly for his trial. So hold on. So what they're saying is, because they don't have the perfect acoustics and that someone else may hear what they're saying, they need to get him out of there. Okay. Immediately upon learning of Mr. Kelly's transfer, counsel reached out to MDC and scheduled a call on June 23, 2021. Mr. Kelly placed a legal call at 7:30 a.m. The conversation, let me see. Okay, so number one, the court approached QCO counsel. The court wants QCO counsel to meet with Mr. Kelly face to face, which will take place. Hold on. Which will take place on or before July 12th. Additionally, it appears that there are scheduling issues with other counsel. Okay. So it says here. Here we go. It says, was brief and there was no legal substance discussion regarding Mr. Kelly's case due to the detention conditions that exist. At present, Mr. Kelly is forced to make phone calls from Italy. They were met with the same difficulties. Mr. Kelly continues to inform counsel of the challenging conditions he is currently placed in, which unequivocally, in an effort to continue to prepare for trial, counsel requested FaceTime or a Zoom call be made available. Long day, y'all. Okay, it says here, even this court seemed to acknowledge the difficulty of using a video conference to communicate with Mr. Kelly versus very difficult for Mr. Kelly to have communications by video. The court went on to say, when referring to on what the issues are, the court went on to say, when referring to on what the issues are and what the potential conflicts may be. This supports the defense's argument that it is close to impossible to legitimately prepare for to the COVID-19 restrictions at the MDC. Understandably, the COVID-19 pandemic has, necessitated the Federal Bureau of Prisons to adhere to certain protocols and avoid transmission or spread of this deadly disease. The requirements imposed by the MDC and BOP regarding quarantine and visitation have undoubtedly created unforeseen delays and a heightened feeling of unrest. You're buffering. Check in the chat. We can't follow you. Hold on. It's still buffering. I don't know why this thing is buffering. Yeah, the reason why it's buffering, y'all, is because they are probably trying to report the channel. So it's important that y'all, if you would, please hit that like button, because they are trying to report the channel, because as you know, the other persons over there are probably reading this. They're trying to put a spin. They don't want y'all to hear this. Okay? So hit the like button if you haven't, please. Let's get back to this here. It says here, understanding that certain COVID-19 quarantine restrictions are required to be followed by the MDC. Such restrictions have impeded counsel's ability to have any meaningful conversations or face-to-face conversations with Mr. Kelly. Both are necessary in order to review the hundreds of thousands. Whoa. The hundreds of thousands of pages of material which dates back for decades, without the ability to sit down face-to-face for long extended periods of time and review strategy and the like. Preparing for Mr. Kelly's trial is an impossible task. Per the MDC, Mr. Kelly must quarantine every time he leaves the MDC and returns. Since Mr. Kelly has been ordered to appear in person for the continuation of the Curcio hearing date, there has been a call scheduled for 1:30 Eastern Standard Time Friday, which will be tomorrow. So there's going to be a call tomorrow, y'all, at 1:30. Yeah, go out and come back in if you buffering, y'all. Go out and come back in, please. All right, let's continue this. All right, so it says here, to be determined, Mr. Kelly is presumed to have quarantine after he goes to court. Again, leaving no direct access to Mr. Kelly or his counsel. Mr. Kelly is set to start trial in approximately 1 month. Sheesh. At the moment, he is awaiting the completion of a crucial hearing and a motion to withdraw by two of Mr. Kelly's defense counsel after being terminated by the client. And given the fact that crucial hearing may not be completed until July 2021, coupled with the quarantine restrictions that continue to create impossible situations for counsel to engage the client for purposes of his assistance in his own defense. A motion for pretrial release and or accommodations for Mr. Kelly is certainly ripe. This request is crucial to guarantee Mr. Kelly's constitutional rights are protected. In the event pretrial release is not possible, given the conditions in the place and time loss, the trial date proceeding on August 9th, 2021 is at risk. Okay. Request for Mr. Kelly's temporary release under 18 USC 3142. The right to access counsel and assist in Mr. Kelly's defense. This court has the authority to grant Mr. Kelly temporary relief pursuant to 18 USC 132. The language of 18 USC is that the court may permit the detainee's temporary release to the extent that the judicial officer determines which release to be necessary. Underscores the discretionary nature of relief under the subsection. The statute goes on to say that the judicial officer may, by subsequent order, permit the temporary release of a person in the custody of the United States Marshal or other appropriate person, to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. They cite case law United States versus Chandler. All right. Further, the court held the right to consult with legal counsel about being released on bond, entering a plea, negotiating and accepting a plea agreement, going to trial, testifying at trial, locating trial witnesses, and other decisions confronting the detained suspect, whose innocence is presumed, is the right inextricably linked to the legitimacy of our criminal justice system. United States versus Chandler, that's more case law. It says here, in our society, liberty is the norm, and the tension prior to trial or without trial is the careful limited exception. These seemingly simple thoughts that an individual is presumed innocent, that an individual should be incarcerated until he has his day in court, and that no matter how damning the allegations against the defendant appear, he is entitled to a fair fight with adequate preparation, should be considered by this court in determining the release of Mr. Kelly from prison prior to his scheduled trial date. Let's see. It says here that failure to release Mr. Kelly will inevitably lead to a reduction of his constitutionally mandated right to assess counsel and to assist in his defense during what the Supreme Court has found to be the most crucial period of a case proceeding, the time between arraignment and beginning of trial. Powell versus State of Alabama. The Bail Reform Act, including a provision that would allow a judicial officer to permit the temporary release of a detainee if the judicial officer determines the release to be necessary for preparation of a person's defense or another compelling reason. So this is looking like they are really trying to understand that they really don't have much time left to go. So they're trying to say, hey, we don't have enough time to even really talk to him. We got hundreds of thousands of pages to go over with this man that go back for decades. How are we supposed to prepare for trial when we only really got about a month to go? Let me see, July, August. Ooh, it's getting close, y'all. Not to mention that the defendant may be the only person that is able to identify, explain, and help his attorneys to understand the evidence and his defense. The court in Vita went on to note that the quality of the detainee's legal defense is likely to diminish dramatically the longer he or she is incarcerated. So they pretty much saying that they will not be able to defend him properly if he is not out of jail. Temporary release with stringent conditions is not uncommon, which is demonstrated in U.S. versus Avenatti. Ooh, they bringing that up. Where the district court determined conditions for release of a defendant who was detained because he violated the conditions of bail that were set at his arraignment after he was subsequently found guilty of murder of multiple felonies. Additionally, the court released the defendant so he could meet. Y'all see what they doing? They trying to tie in the fact when you let Avenatti out, and he was already convicted, and this man ain't been convicted yet, and y'all still got him locked up. See what they trying to do. Additionally, the court released the defendant. So that he could meet with his counsel and prepare for the two impending trials, and doing so under the current conditions would have made that impossible. The court clearly stated this order does not withdraw, is not derogation of, and does not conflict with the court's prior findings. And the Ninth Circuit's affirmance of this court's finding that there is probable cause to believe that defendant committed state and federal crimes while on pretrial release. The defendant is a danger to the community, and that the defendant failed to rebut the presumption that no conditions or combination of conditions will assure the safety of the community. U.S. versus Avenatti. There's a problem. Hold on, the new attorney isn't ready. There is a problem. Yeah, no, they're not ready. It says here the following conditions were included. A defendant shall participate in the location monitoring program and abide by all requirements of the program. So what they're trying to do is they're trying to say, why don't you give R. Kelly the same restrictions you gave Avenatti? Pretty much. Program by all requirements of the program under the direction of pretrial services, which shall include a location monitoring bracelet. Defendant must pay all the cost of the location monitoring program based upon his ability to pay as determined by pretrial services, and will be financially responsible for any loss or damaged equipment. Defendant shall not possess, use, or access any digital devices that offer or allow internet access. Defendant may, however, possess and use non-internet connected telephone approved by pretrial services to communicate with his attorneys, family, friends, or other basic living needs during the 90-day term of his temporary release. Although the defendant may not possess use or access to any internet-enabled digital services, the order does not preclude defendant's legal counsel from emailing legal documents to defendant's third-party custodian, which is Jay Mannheimer. So that defendant's... Okay, let's see where we at. Says here, so that... Hold on. Where'd you go? There you go. All right. For release, the only option left that would ensure Mr. Kelly would be ready for trial. Unlike Avenatti, Mr. Kelly has not been found. I just told y'all they was going to try to use that. Here we go. Here we go. For release is the only option left that would ensure Mr. Kelly would be ready for trial. Unlike Avenatti, Mr. Kelly has not been found guilty of multiple felonies, which sentence could carry a significant amount of time. But like Mr. Kelly, has multiple cases that contain an enormous number of documents, which requires hours of in-person consultation. Avenatti, a lawyer, has experience in litigation, and even with meeting with his lawyers, has complained about the difficulty of preparing for his trial while detained. Turning to Mr. Kelly, significant time has been lost because of his transfer. He has significant learning disabilities, and given the complex nature of the case, needs to review and discuss the discovery with his counsel and cannot be met now, or even after his quarantine ends. Although prior to his motion, Mr. Kelly has been denied pretrial release on at least 3 occasions due to the fact that counsel at the time failed to show this court compelling reasons for pretrial release. This motion is riddled with compelling reasons given the current circumstances. The court is consistently found that no condition or combination of conditions will reasonably assure Mr. Kelly's appearance as required and the safety of any other person in community. Since the last bond argument, which was on May 15, 2020, there have been a number of significant changes in Mr. Kelly's circumstances. Y'all hold one moment. Had to turn that light a little bit. It's killing my eyes. Mr. Kelly's circumstances. The government primarily objected to pretrial release on their responses to the defense's previous motions for bond, stated that Mr. Kelly is a flight risk and a risk to the public and a risk to public safety. The case of United States versus Thornton, they talk about more case law, suggests that the district court can temporarily release a detainee pursuant to 3142 even after a prior order holding that the detainee was a flight risk or a risk to public safety. Additionally, the court, United States versus Stevens, constitutes a separate statutory ground for post-conviction release that the defendant's inability to communicate regularly and effectively with counsel in light of the BOP's visitation policies satisfy requirements for release under 3142. Third party custodian can print them for defendant to review. Defendant may also access and use an internet-enabled digital device while in presence of defendant's legal counsel, solely for the purpose of preparing his defense in the case and in the 2 pending prosecutions in Southern District of New York, United States versus Avenatti. They're going to ride this shit all the way. And United States versus Avenatti, defendant shall avoid all contact except in the presence of counsel, directly or indirectly, with any person who the government has identified as victim or potential witness in this prosecution and investigation, except for Christine Avenatti Carlin. Defendant, however, shall not engage in any substantive discussions with Mrs. Carlin regarding his prosecution and investigation, except in the presence of counsel. The defendant shall comply with all court orders, including but not limited to any conditions of release in United States versus Avenatti and United States versus Avenatti. And the defendant shall surrender all passports and travel documents to pretrial services within 24 hours of his release, to the extent that he has not already done so, and also sign the declaration, passport, that other travel documents form, and shall not apply for any passport or other travel document during pendency of this case. Man, they are really throwing Avenatti up in here, aren't they? Hold on, let's see. Hey, y'all, them dislikes is piling up. Y'all ain't liking what's in this paperwork. That's all we doing is reading. Y'all don't get mad at me. All I'm doing is reading. Don't get mad at me. These rulings speak directly to the case at bar due to the fact that Mr. Kelly needs to prepare for his defense for his upcoming EDNY case. The present jury trial date has planned without knowing that a crucial hearing was going to take place and not be completed until a few weeks or days before Mr. Kelly's jury trial is scheduled to begin. Given the numerous hindrances that have occurred in counsel having access to their client, it is nearly impossible to expect the defense to be prepared while Mr. Kelly remains in custody. Hold on. Remains in custody. Moreover, attorney-client communication is an essential component of the meaningful access to courts guaranteed under the Constitution. They cite case law. See, Dre versus dang, it's a lot. Okay, internal citations omitted. It's a whole bunch of case law. Hospitalized pretrial detainee with AIDS stated claim for violation of his constitutional right of access to the courts because of hospital detention policies that prevented him from attending court. Filing motions, including to reduce his bond and meeting with counsel. The court found that the opportunity to communicate privately with the attorney is an important part of that meaningful access to courts under the 14th Amendment. If a lawyer is unable to go to the jail because of the virus, is under mandatory quarantine because she or someone she is close to is exhibiting symptoms associated with the virus or has been exposed to someone who has tested positive, he can only communicate with his client by phone. Okay. So, it says here, the question is whether there are any conditions that would permit release. Here, conditions can easily be fashioned to ensure Mr. Kelly's return, pursuant to 18 U.S.C. 3142. The defendant is prepared to. Here's what he's prepared to do, y'all. Execute a bond co-signed by a financially responsible person. Okay. Number 2, be placed under 24-hour home confinement to be enforced by location monitoring technology to be determined by pretrial services. Mr. Kelly would only leave the residence for necessary medical services. All other leave from the residence would be submitted through the defense counsel for the court's approval. Number 3, Mr. Kelly would not be released from the MDC until all conditions are met, including the availability of location monitoring equipment. Number 4, a review by this court not to exceed 15 days, at which time the need for continued release under the compelling reason that release was ordered can be revisited by the court. Number 5, when home visits are scheduled by pretrial services, Mr. Kelly will comply with pretrial services requests to remove all cohabitants of the resident prior to the visit. Let me read that one more time, because that sounds like he would get Joyce's ass out of there. Let's see. When home visits are scheduled by pretrial services. Okay. When home visits are scheduled by pretrial services, Mr. Kelly will comply with pretrial services request to remove all cohabitants of the residence prior to the visit. Okay. It says see full list of Avenatti conditions at footnote 3. There we go. Let's see. In sum, Mr. Kelly is being denied his Sixth Amendment right to access to counsel. There is no iron curtain drawn between the Constitution and the prisons of this country. Wolf versus McDonald, they cite more case law. A court should not unjustifiably obstruct the availability of professional representation or other aspects of the right of access to the courts. Therefore, restrictions imposed by the district court should not dwarf Mr. Kelly's Sixth Amendment right to have access to his counsel and to be able to prepare for his trial. Mr. Kelly maintains his innocence. He moves for temporary pretrial release under 18 U.S.C., which permits a court to order the temporary release of a detainee when necessary for preparation for a person's defense or for another compelling reason. The defense would be remiss if counsel failed to address an obvious stumbling block in Mr. Kelly's ability to assist counsel in his own defense. It is undisputed that Mr. Kelly cannot read or write. Therefore, unlike most defendants, he cannot spend hours reading and reviewing the documents that are relevant to his case. He cannot make notes about the documents in order to share those thoughts at a later time with his counsel. He cannot meaningfully communicate in writing with his lawyers. He cannot refer to the dictionary or internet to look up legalese. He cannot effectively use the law library in person. And he cannot meet face-to-face with his lawyers who can answer and explain and obtain his feedback about discovery materials. On February 4th of 2021, this court ordered that Mr. Kelly the ability to possess in-jail facility compact disc on a single paper copy of the protected 3500 material that may review such material outside the presence of defense copy of the discovery or the 3500 material. The request fell on deaf ears. Not only did Mr. Kelly not receive a single paper copy from Mr. Greenberg, of which he could have tried to struggle through and has a right to have, but Mr. Kelly never received that disc either. Mr. Kelly has not received a single piece of paper that is part of his discovery, and all his legal notes and paperwork are still at the MCC because he was not permitted to travel with anything. Wow. Mr. Kelly is essentially been cut out from the discovery and trial preparation process. Moreover, because of the pandemic and the visiting hours for attorneys at the MDC, his overall communications with counsel in assisting in his own defense have been cut out. Now, both Mr. Kelly and counsel await what has amounted to a sporadic and unpredictable times for a phone call. Now, given these types of limitations, it will be impractical to believe that Mr. Kelly will be able to assist counsel in fighting for his life. This is particularly troublesome, and the means of those limited communications do not even possess the safeguards of confidentiality that are necessary to engage in meaningful attorney-client conversation. Now, as stated above, when counsel had FaceTime visits with Mr. Kelly at the MCC, a camera was placed in clear view, both behind and in front of Mr. Kelly as he spoke to counsel. This has caused all sorts of lack of confidence when it comes to attorney-client confidentiality. It was as though the attorney-client relationship had been, let's see, had been completely ignored. It is just another stumbling block in the pursuit of justice for Mr. Kelly that cannot be untold. There is no denying that this is an extraordinary time, and that the issues that ordinarily affect bail determination have to be viewed differently and more liberally. This is the time, if ever there was a time, where pretrial release should be granted based on the litany of compelling reasons presented to this court by the defense. Now is the time. The COVID-19 required restrictions at the MDC toward both Mr. Kelly and counsel for preparing for August trial date. Not only is Mr. Kelly's constitutional right to assist his counsel and his defense being violated, but due to COVID-19 pandemic, the required preventative measures for avoidance of the contraction of or spread of the disease per the BOP presents additional hurdles and setbacks when it comes to counsel's ability to prepare for trial that is slated to even in proximity to 1 month. The COVID-19 virus is a potential life-threatening disease that inmates continue to need to be protected from contacting or spreading. As of June 25th, 2021, the BOP had 54 and 6,878 staff contracted the deadly disease. Safeguards to prevent the spread of COVID-19, which are to be adhered to meticulously, are still very much in place at the MDC. As of January 22nd, 2021, the CDC recommended that the combination of getting vaccinated and following other CDC recommendations for protection that offers the best protection from COVID-19 at this present time. The CDC stresses the importance of wearing masks or cloth coverings to help reduce the chances of being exposed to the virus and spreading it to others. Now, the CDC also explains that the importance of social distancing with the BOP in order of the infection. Per federal BOP inmates with no prior history of COVID-19, Mr. Kelly should be tested prior to a transfer, and if negative, placed on release transfer quarantine. On June 22nd, 2021, it was presumed this step was taken by the MCC. Let's see here. All right. It says here, prison is separately from inmates in exposure or intake quarantine. Once Mr. Kelly arrived at the MDC, he was immediately placed in the SHU, a tiny cell, usually about 6 feet by 9 feet in size. Another inmate was placed in that same cell with Mr. Kelly. That inmate entered Mr. Kelly's cell without wearing a mask. That inmate has never worn a mask while at the MDC. The MDC does not require a mask to be worn in a cell. These facts are very concerning given the importance of the BOP and CDC have placed on wearing masks and social distancing. Mr. Kelly's cell, which is barely big enough for one inmate, has 2 inmates bunking together who did not get transferred to the MDC together, who are not able to social distance within their cell and are not required to wear masks. I got to get something to drink, y'all. Hold on. I don't see how Larry do this. Whew! Shout out to Larry. Shout out to Larry. Okay. Here we go. It is also well known that the stark reality of placing an inmate in a SHU causes a slew of mental health issues, including but not limited to hallucinations, anxiety, panic attacks, memory deficiencies, concentration issues, paranoia, and impulse control. Based on Mr. Kelly's placement in the SHU, he is experiencing a number of these mental health issues. It does not help that Mr. Kelly was erroneously placed in the SHU for 70 plus days when he was first incarcerated at the MCC, and still has nightmares to this day about his experiences in the SHU. Inmates placed in the SHU, whether for punishment or for protection, are subjected to virtually the same conditions as those confined in the SHU due to disciplinary infractions. The mental anguish alone that Mr. Kelly is experiencing from being in the SHU again thwarts counsel's ability to involve Mr. Kelly in assisting in his own defense. Now, Mr. Kelly's mental state plays a large role in his ability to assist his counsel in his defense. The appropriate mind frame necessary in this crucial time in his case to assist counsel in his defense cannot be accompanied given Mr. Kelly's current situation at the MDC. Even social distancing cannot take place in his cell, which simply heightens the risk of Mr. Kelly contracting a disease, which is just another insurmountable hurdle that Mr. Kelly faces if he remains at the MDC. During the bond hearings, several of the CDC guidelines were cited as reason for why Mr. Kelly did not deserve a bond, nor to be released under any circumstances. Now, since the previously bond motions, the CDC has broadened their guidances when it comes to who is the most vulnerable to contracting COVID-19. In June 2021, the CDC indicated that adults of any age, adults of any age with certain medical conditions can be more likely to get severely ill from COVID-19. This eliminates the prior representations by the CDC that the group of people who were previously categorized as most at risk for contracting COVID-19 and getting severely ill from it were older adults approximately 65 years old and up. Now, under the current CDC guidelines, Mr. Kelly at the age of 54 with certain medical conditions contracted since he has been imprisoned would be more likely to get severely ill from COVID-19, which perhaps a man of similar age and stature without the same medical conditions that Mr. Kelly continues to suffer from. The CDC broadened their list of potential medical conditions that could make a person more likely to get severely ill and or cause death from contracting COVID-19, including in that list of potential medical conditions that increase the risk of getting COVID-19 is diabetes and chronic lung disease, including chronic obstructive pulmonary disease. While incarcerated, Mr. Kelly was diagnosed with type 2 diabetes and tuberculosis, a disease that causes bacteria to attack the lungs. Unfortunately for Mr. Kelly, his type 2 diabetes has never been treated properly at the MCC. Months ago, without a nurse performing a blood sugar reading. Per proper health standards, with type 2 diabetes, a person should take a blood sugar reading at least once a day. Due to Mr. Kelly's new diagnosis of type 2 diabetes, Mr. Kelly was told by the doctor at the MCC that he should start eating healthier. On July 10th, 2020, the doctor from the MCC ordered that Mr. Kelly was to retrieve what's known as a heart-healthy diet meal. Mr. Kelly never received one heart and healthy diet meal. Past history of tuberculosis is an important risk of COPD, and tuberculosis is also common in COPD patients. Development of chronic airflow instruction may be related to common risk factors or tuberculosis associated with lung damages. At the MCC, Mr. Kelly was given a proper round of medication to combat his tuberculosis, but Mr. Kelly remained vigilant in wanting to understand and be informed about his tuberculosis diagnosis, because although the TB germs become inactive, they remain alive in the body and can become active later. Even if there is a question about Mr. Kelly's diagnosis would lead him to be high risk or not, the trial courts have generally not required that a detainee actually be classified as high risk as a prerequisite of granting release from detention under 3142. They cite more case law stuff about corona. All right. And last page. Release is necessary for the preparation of the person's defense or for another compelling reason. Accordingly, this court does not even need to reach the issue of how COVID-19 pandemic is personally affecting Mr. Kelly's health in order to determine that release from custody is appropriate. Notably, while incarcerated at the MCC, Mr. Kelly begged counsel for an outside evaluation for both his mental and his physical state from his days in the SHU. And since he's contracted two very serious diseases in January 2021, both Mr. Leonard and Mr. Greenberg promised Mr. Kelly that they would have those services provided for him, with the understanding at the time that they would have to be via FaceTime. Mr. Leonard specifically took on the role committing to making those visits happen for Mr. Kelly. After several reminders to Mr. Kelly, both Mr. Kelly and co-counsel, unfortunately, Mr. Kelly's well-being, neither Mr. Leonard nor the lead attorney, Mr. Greenberg, followed through with the client's important request, which left Mr. Kelly in the dark about both of his mental and physical state. The extraordinary burdens imposed by the coronavirus pandemic restrictions, in conjunction with Mr. Kelly's right to assist in preparing for his own defense, certainly constitute compelling reasons that will permit this court to order the temporary release of Mr. Kelly, pursuant to 18 U.S.C. 3142. The obstacles the current public health crisis poses to the preparation of the defendant's defense constitute a compelling reason alone. The circumstances as they exist now will continue, but for his attorneys to appropriately prepare for a very quickly approaching jury trial. Mr. Kelly has received no assistance given the fact that he is illiterate and has difficulty reading and writing. Conclusion. For the foregoing reasons, Mr. Kelly respectfully submits that he should be released to prepare for his defense for the impending trial now scheduled to begin on August 9th, 2021. Respectfully submitted, Thomas A. Farinella and Nicole Blank Becker, counsel for Robert Sylvester Kelly. Wow. So what y'all think? Do y'all think that it's any way possible that this was better than the rest of the ones that they filed and got denied on? Do you think they have a actual argument here? They talk about the coronavirus. They talk about the fact that Avenatti got out. He's already been charged and convicted. They let him out. Would you say he actually has an opportunity to get out? Hey, April Showers. Hey, everybody. What would y'all say? What would y'all say? We just read the whole doggone thing. My personal opinion, I personally think if he was going to be let out, he would have been let out already. I don't feel as though that the court cares about his need to be prepared for this trial. I think that the government just has enough information that's damning to no matter how much preparation he does, it's not going to matter. I hate to say that. I know I got R. Kelly supporters over here, but that's just my personal opinion. I just don't think that I don't think they care. I don't think they care. Yeah, you gotta try, right? You gotta try, but yeah, they kept recycling the same thing over and over and over and over and over again. But as you see, they are trying to. I believe the timing of when this was entered has a lot to do with Bill Cosby getting released yesterday. I think they're looking at the climate of society right now, and I think they're thinking, okay, well, there are people on that side over there. They really believe that because Bill Cosby got released, that R. Kelly's next. They really believe that, but there's not videotapes of Bill Cosby doing these things. Not that I know of. If I'm wrong, y'all tell me. There's not like visual evidence of him doing it. He has a confession that he, did some things, and he was told if he said those things, he wouldn't be convicted. And he went to jail, and then they let him out because they said, we told you we wouldn't do this, but somebody didn't follow the, agreement. But at the end of the day, this case is totally different than Bill Cosby's. Completely. And I think it's crazy that they are trying to use the Avenatti case as a way to compare the circumstances in which Avenatti was given treatment as far as one of the dumbest motions that I think Greenberg and them filed. And I still to this day don't understand. And if I'm using the wrong terminology, y'all can correct me later. But when they filed that one saying that R. Kelly wants to get out to go atmosphere, that shows negligence. It almost seemed like a setup. That's kind of like saying, we are going to release this crackhead to a trap house. He's in here convicted of abusing, manipulating, taking advantage of, holding hostage, all these things of young women, and you're saying we're going to release, we want him to be able to go back to his girlfriends. I think it would have sounded a hell of a lot better if he would have said, listen, his wife and his kids miss him. We want him to go back to his wife and kids. I know they're not married no more, but that would have been a more compelling argument. His kids miss him. He's going to be at a location with a full-time babysitter that is a family member who is going to be there with his kids, and he just wants to be with his kids while he learns about his case. That would have been a hell of a lot more convincing than to say, let him leave so he can go be with his girlfriends. Let him leave so he can go home with his girlfriend. Which one of y'all niggas wrote this? I don't get it. I don't understand what kind of lawyers are gravitating to want to jump into this case? Do they just think that because they keep... I would be insulted as hell if my lawyers just kept saying he's stupid, he dumb, he illiterate, he can't do this, he can't do that, he's an idiot. That's all they really kept saying. He's an idiot, he's dumb, he can't read, he can't write. They just kept hammering that to the judge's head. Boom, boom, boom. Like, that's going to make her feel guilty. If there was any time that I think he would have got out, it would have been way before now, y'all. The case is coming up. And at the time when R. Kelly had Greenberg and them good, and they asked, is there anything that would make us have to postpone this trial starting on time? The lawyer said, no, we are ready to go to trial. Or there was a government that said they ready to go. They ready. But Greenberg and them said they was ready. Both ready. No halts. No reason to stop anything. Nah, we good. Let's go. And then R. Kelly say, I don't want y'all to be my lawyers no more. Probably because he listening to some dumbasses out here on the outside who claim they have direct connection with him. Y'all think about that for a minute. What's up, Tears? Yeah. Them 100 devices, man. Look, you can say what you want to. You can feel sorry for them. But there's a reason why that man is not going to be getting out. And I hate to say it, and I know y'all hate when we say it, but he going to be denied again. Like, I just don't, based on that motion, I don't see a reason why they would let him out. Not based on that. Not based on Avenatti. It'd be different if Avenatti had the same type of charges. Right? They say he had, child pornography and, all these other things and racketeering and all that. And then they let Avenatti out and he actually, you know what? You got a point. Avenatti did white collar crime stuff. He stole money from Nike and other big companies. That's what he did. The man acting, transporting kids over state lines and having sex with minors and all kind of good grief, man. This man got... Correct me if I'm wrong. For somebody that can't read, you mean to tell me they're going to be able to get through hundreds of thousands of pages? It's a wrap. And then you got these lawyers. You got Farinella, you got Nicole. They're going to do this Kershaw hearing to even determine. No, I'm going to take you off and I'm going to put somebody else in. I want to do what's best for the client. And I don't believe you're it. Then what? R. Kelly might have screwed himself. This might have. Thing. As if that's really going to move that judge. The tires, bitch. The tires, people getting vaccinated and people wearing their masks more, and it's really not as big in the news. It's not as big in the public as it. Why not as big in the news? It's not as big in the public as it. Why now? Why now? 9 days? Adding in the fact that if he leaves, he got to come back and do quarantine for 14 days? 14, yeah, that's 25, right? 39 minus 14. 25. That's really then 25 days that you have to go over hundreds of thousands of pages with him. Yeah, he has been vaccinated. That's true. He has been vaccinated. But they still have him on quarantine. So, y'all, I'm glad that, everyone has their own interpretation. We just read it. We just read what we see. We don't offer any conspiracy theories behind what we read. We just read it. That's why people respect where we come from, because we just reading the paperwork. The paperwork is the paperwork. That's all we doing. Right? But I want y'all to go ahead and get some rest, man. I'm sure some of y'all got to go to work tomorrow. I know I do. I love y'all. I appreciate y'all for tuning in tonight. Thank y'all for came over that supported the battle earlier. I'm going to be working out my technical difficulties this week so that I can make sure that they are ran a lot more smoother. But y'all are incredible. Thank y'all for coming over here tonight. And please, if you would, if you haven't hit the like button, hit the like button. If you want to leave a comment, let me know if you do like me reading this or not. If it's boring to you, let me know. It's all good. But I just want to keep y'all informed, especially from this side, because sometimes when you hear them talking on the other side, they spin it so much to make it say something that it's really not saying. And I think it's only right that we hear things from the truth aspect, which is just straight reading the paperwork legibly and just calling it like it is. Okay? But I love y'all. Thank y'all. Y'all have a blessed night. I'll holler at y'all later. Peace.